All right. So what we're going to do here is I'm going to go over some proposed rule changes from the Department of Labor and something that I propose that we do to try to remedy it. I'm going to go through background, how things are done now, how the Department of Labor proposes it's going to happen, what some of the implications there are. So what you can do in the meantime, while we are going through this, is just if you have questions, you can either put it in the Q&A. Just so you know, if you put it in the Q&A, I think everyone can see it, although we do have it set to anonymous. However, if you go into the chat, you can send messages just directly to us. So those will only go to me. I'll only be the only one able to see that. So there's the chat function that's down there at the bottom of the Zoom thing, the Zoom window. But all right, cool. Well, let's go ahead and get started. So I want to give everyone a little bit of background on how H-2A wages are ordinarily determined. So the way that they've done H-2A wages historically is they have taken the statewide average of all agricultural occupations and then come up with an average. And they make this the same wage rate for all H-2A workers, regardless of occupation throughout a state. This is called the adverse effective wage rate. And it varies based off state. And one of the benefits of the adverse effective wage rate is that it gives some level of certainty in terms of wage prediction, but also the timing that they change the adverse effective wage rate generally doesn't impact people that much because it's during where most H-2A workers are gone, which is they usually do it at the end of December, beginning of January, where they change the adverse effective wage rate. And that requires employers to, if they do have workers here, and let's say a wage rate goes up in a state and goes from $15 an hour to $16 an hour, and the employers have to change the wage rate for those workers while they're here. But otherwise, you're filing applications for the working season, knowing that you have this wage rate over the course of the whole year. So the Department of Labor has been concerned about this for some time because they think that there are certain occupations where the wage rate is being artificially depressed. This is the Department of Labor's perspective, not mine. What the Department of Labor is proposing is changing the methodology to determine the appropriate wage rate for various occupations. And many of these occupations impact a lot of our clients. And so I wanted to make sure that our clients are aware of this and that they can kind of plan for it moving forward. And I'm going to go through a lot of, I'm going to be going through quite a bit of stuff here. So what the Department of Labor is looking at, particularly some of the ones of interest, would be construction occupations. So we have a ton of clients in the Midwest that file to construct livestock confinements, for example, or grain bins, those sorts of things. And so the Department of Labor is proposing to change the wage rate methodology for all those guys. They'll also be changing it for a bunch of other H-2A employers that require a commercial driver's license, for example, for their job. So that matters a lot. And so the way that the Department of Labor is proposing that they change the methodology is for these certain occupations, they are proposing using what's called the statewide OEWS survey. So the OEWS survey is conducted by the U.S. Department of Labor every year, and they come up with a statewide average for a given occupation. Now, there's a huge flaw with that, and that's that if you take a statewide average of a wage rate in a state like Minnesota, for example, a lot of that's going to be unfairly skewed towards the metropolitan areas as opposed to the rural areas where the wage rates tend to be significantly less, the cost of living significantly less. However, the employers utilizing H-2A visas in those states will have to pay the statewide average, which takes into large consideration those metro areas. And so I think it's a very flawed method of determining wage rates. So this is how the Department of Labor does it. Whenever you file an application with the state workforce agency, that's where you're advertising your job to the U.S. workforce. And in doing so, the state workforce agency fills out this small part on that form. It's called the ETA 790. And one of the questions there is the state workforce agency is charged with the responsibility of applying the proper SOC code. And the SOC code is just how they classify the job. Okay, I'm looking at these job duties. Based off these job duties, I believe that these workers fit in this bucket. And what the Department of Labor is proposing here is that the state workforce agencies look at the various job duties on the application, the job duties the workers are going to be performing, and they apply the highest SOC code. So let's say, for example, that I'm an agricultural construction company and I perform concrete work, rebar work, carpentry work. Let's say I do all of it. Well, so I put all those on one application. What the Department of Labor is going to do is they're going to look at that job description with all those different job duties, and they're going to say, okay, so carpenter wage rate is this, concrete finisher wage rate is this, rebar worker is much higher, but it's this. Well, the Department of Labor is going to assign for all of the work the highest applicable wage rate. So let's say that the rebar workers the wage rate there is $30 an hour, concrete finishers $25 an hour, carpenters is $20 an hour. Well, it doesn't really matter if your workers are performing carpentry work or rebar work, they're going to apply the $30 to all of it. And so it obviously has huge implications. It also has big implications in terms of how people actually file their applications, because the nice thing historically is we've been able to group those job descriptions together because the same people are performing the same work, or some of all that work, I should say. So let's say I'm an agricultural construction company and I perform framing work and equipment installation work. Well, historically, I've been able to just put that on one application, and it's been fine because my workers will go do the carpentry work and then they'll go do the equipment installation work. Well, with this, you would want to take a close look at the actual wage rates in the state based off of each occupation to determine if that is worth the cost. Because what the Department of Labor's intent is here, and this is what the Department of Labor told us at a meeting, I think it was in January, is that in reality, a lot of employers are going to start having to bifurcate their filings whenever they historically haven't had to. So not only do you have the increased cost as it relates to actual wage rates, you have increased filing costs and expenses, which is something that frankly none of us want. So that's kind of where we're headed, and I'm gonna go ahead and show everyone real quick a spreadsheet that I made of some common SOC codes that we've got over the last year. Remember, if you have questions that come up, put them in the chat box there, and I'm gonna address them as they come in, or maybe I'll address them at the end. I don't know. We'll see how it goes. Okay, so let's see here. Let's see what this one is. So I want to make sure I get the right one here. Sorry, one second. Wage rate is after. All right. All right. Can someone please put in the chat box that they can see my Excel sheet here? I just want to make sure it's working. Awesome. Thank you. Okay, cool. So here are some of the common wage rates. There are some common SOC codes with some common states where we file, and you can see the implications. So for carpenters, framing companies, I anticipate most framing companies will want to bifurcate their filings based off of it if they're performing carpentry helper work or actual carpenters. But you can see what some of the wage rates do here. Let's go down to Illinois. This is a good one. This is a good one to demonstrate the overall implications here. I just so you know, I highlighted in red some really big increases. There's some states where the increases aren't quite as bad. Like if you look at South Dakota, for example, wage rate increases are significantly more modest than a state like Illinois. So let's look at Illinois. Okay, so carpenter wage rates, based off of this, would go up 101%. Cement masons and concrete finishers, 119%. If you were grouped just as construction laborers, it would go up 87%. Reinforced iron and rebar workers, 188%. And then this is how some of our equipment installation companies have been classified. This is Idaho, though. Let's see if we have that one for Illinois. Yeah, we do. For Illinois, right here, 94%. So as you can see, the cost of construction of livestock confinements in the state of Illinois is going to go through the roof. And the thing is that, yeah, sorry, and I just saw that. Let me zoom in here. There you go. Is that better? Good. You can see that. Got it. Cool. So as you can see, the cost of construction of livestock confinements in the state of Illinois is going to go through the roof because you've got your carpentry people here. Your carpenter helpers aren't going up that much, but your actual carpenters are. Your concrete going through the roof, and then your equipment installation, very, very high. So I think what's probably going to end up happening is because most of these livestock confinements are built by H-2A workers. They're not built by U.S. workers. The workforce just isn't available in the United States to actually perform this work. And so I wouldn't be surprised if we start seeing a lot of people that are producers in Illinois start moving over to a state more like Iowa, because look what's happening in Iowa. You're having some wage rate increase, 37% for carpenters, 32% for concrete finishers, 25% for construction laborers. Roofers, I had roofers on one of them, so I put that in there too, because they were installing roof sheet metal. And then look at this, equipment installation, 66%. So, but that's significantly less than the state of Illinois. I mean, what's going to end up happening is the actual cost of production of livestock in these states is going to vary tremendously based off of the wage rates to actually build the confinements. So we'll probably see a lot more people building in Iowa. Kansas also not too bad. It's not great. You're still going up 40% for reinforced iron and rebar workers, but you're not in the state of Illinois going up 188%. That is just absolutely mind-blowing. I just got a question. The percent increase is based off of today's adverse effective wage rate and the prevailing wage for today. So this is as if this went into effect today. I would actually anticipate this perhaps get a little bit worse next year. So let's see here. If you have any particular states that you want to see, just put it in the chat box here. Happy to show you any particular states and any particular job codes too. But look at this one. So let's take a look at Minnesota, for example. Minnesota carpenters up 80%. Concrete finishers, 91%. Reinforced iron and rebar workers, 130%. Equipment installers, 98%. I don't think, and Minnesota also has the variable of having to pay overtime to agricultural workers after 48 hours. And so you're paying the overtime on that much higher wage rate. Wouldn't expect a lot of future construction in Minnesota either. Okay, let's see here. North Dakota. So equipment installers here. Okay. Oh, there's one more thing to mention about a state like North Dakota. Whenever there's not a statewide average for a particular SOC code, the way the Department of Labor is going to do it is based off of the national average of that SOC code. And so North Dakota has cement masons and concrete finishers, which is going up 38%, equipment installers 88%, and construction laborers 31%. But they will use the national average for something like rebar workers, for example. So that's something to be aware of. And I'm happy to send those afterwards if you send us a message. All right, Missouri. Oh, wait, sorry, New Mexico. Let's do New Mexico first. All right, New Mexico, not too bad, although the rebar workers, so your concrete is going to be expensive in New Mexico, because the way that they would do it is normally a concrete company would have the same people do the actual rebar work as they would the concrete work. And so they would assign the 96% to all of that. Everything else, though, is relatively modest, except for equipment installers, also really high. One quick note about equipment installers is this has been an area of tremendous inconsistency with the state workforce agencies assigning of these job codes. So I used industrial machinery mechanics because this is the one I've got most frequently. But also, this is probably the worst case scenario for equipment installers. There are a number of other ones that wouldn't be nearly as bad, but this is what I've seen most lately. So it's something to be aware of. Okay, Missouri. Okay, carpenters 67%, 51% for cement, mason, and concrete finishers. 101% for reinforced iron and rebar workers. Yeah, Missouri was another one that I was actually particularly surprised about. And just so you know, if you ever see a negative percent, that means that they would assign the adverse effective wage rate. Okay, California and Washington. California, equipment installers 103%. Concrete workers 85%, carpenters 80%. And California already has high wage rates. Same thing with Washington. Washington already has high wage rates. And let's take a gander at the implications here. Carpenters 83%, equipment installers 82%, concrete workers, so they must not have had rebar in the data, so you can say 74%, and I can look at what the national average is for rebar workers. Okay, can we see truck drivers in agriculture in Kansas? Happy to. I don't have so here's the truck driver occupation. In Kansas, wage rate going up to right there, $24.50 an hour. Okay, so a question about sending this Excel document. Yeah, I can send anyone that requests this Excel document the Excel document. Okay, so I get one thing to be aware of also with this that is particularly troublesome is with the adverse effective wage rate, it is redetermined every January. All of these wage rates, on the other hand, are redetermined July 1st, right in the middle of the working season. So I'm not exactly sure how employers are supposed to effectively predict their cost whenever it could go up pretty substantially right in the middle of the season. The only thing that I can think of potentially doing would be having certifications that end sometime in July or August, and then filing with the new ones and you would also have to increase your wage rate. So if wage rates go up in July, you have to increase your wage rates in July. Okay, so then I got another question. Can you dispute the wage assignment? Yes. So this is another part. So the Department of Labor on Friday released a final rule. I'm still going through it. It's 600 pages long, and it's not exactly riveting. But one of the things that they did in there was they made it to where you couldn't appeal a deficiency notice you have to appeal after denial. So let's say that you wanted to dispute a wage assignment. The way that you would dispute the wage assignment would be to go through your application, accept the denial, appeal. In the appeal process, argue your case for the wage assignment, get it sent back to the Department of Labor, and then have your application continue to be processed. So can you dispute it? Yes. But the big problem is that it starts pushing back your application because it takes about a month to get through an actual appeal. And so if I want to get through an appeal and it takes me a month, that's going to have implications on my start date. And so that sucks. That was part of the new rule change. Okay. So if this effectively this happens, it's going to dramatically reduce all ag-related construction, as new construction won't be feasible until supply demand changes enough to increase commodity prices. Correct? That's correct. Yeah. So if this goes through, the implications here would be, that there's probably some states where new construction will make a lot of sense. Like South Dakota, look, I mean, that sucks, but that's not going to stop new construction in South Dakota. I think what we're going to see is more competition in those particular states because the cost of production in those states are going to go down. And so, yes, that's going to happen with new construction, but you also have a problem with remodels, for example, because this is also the case with remodels. Whenever you file an H-2A application to do a remodel on a building, you're still getting assigned an SOC code, and you still have to go through this process. And now, is the Department of Labor good with that? I don't know. I don't know it's hard to assign malice there. I guess the Department of Labor, they are under a lot of pressure to get wage rates right to make sure that they're not adversely affecting the U.S. workforce. That's part of their actual responsibilities. And so the Department of Labor being good with that, I don't know that the Department of Labor fully comprehends the implications this is going to have on new construction and agriculture. But what would happen is commodity prices would catch up eventually, causing food prices to go up, and then it would make new construction start again. But the reality is that you're not going to be doing this work with anyone else because the people aren't here to do it. There's just no one. It's hard to find people in Austin, Texas right now to do construction work. The idea of getting them into the middle of nowhere in Nebraska, I think, is unlikely. So I do think it's going to have some pretty serious implications. There's going to be a little bit of a industry shock in terms of the prices. Okay, if you appeal it once like that, does it help you going forward? It probably would. It certainly would. So this was a great question. So this is a follow-up to the question of if you appeal the assignment of your wage rates and you win on the appeal and get the wage rate that you're looking for to be assigned, will that help in your future filings? Yeah, because then you can cite that and they would be fine with it. Now, Department of Labor might want to continue to push you on it, but you could certainly, that would certainly help you. Yeah. So I think what will probably happen is there will be a ton of appeals at the beginning of next year, getting the proper wage assignment, and then it'll be better going forward. So this question, there's no rebar worker SOC code in South Dakota. So does it go by federal average? That's right. It would go by federal average. Yeah. Okay. So now let's talk about some of the risk. So let's say I'm a construction company and I try to dumb down my duties. Okay. Let's say that I'm a carpenter. I'm a framing company, and I occasionally let any of my guys that want to hop on a forklift or run a skid loader. Well, that would present some problems, because what if the equipment operating job SOC code wage rate is significantly higher than the carpenter? if the Department of Labor would have known that going into it, they would have applied the higher wage rate to the whole application. So what does that do in an audit? That makes it where the Department of Labor goes after you if you didn't properly file your applications for back wages for all of your workers. And H-2A audits, the part where the money really adds up, the civil money penalties suck, but the part where the back wages add up is the part that has the biggest implications in DOL audits. So that's why that matters. So there's a few things that you can do there. Write down all of the job duties that your people will be doing. All of them, no matter what they are, and then put them all together. If I'm your attorney, send them to me, and I'll try to help you if there's any way to separate them into separate filings so that, you know, maybe some guys are getting paid more, but you're doing it compliantly and you're not going to get hit with back wages for the whole group. To separate your filings into two separate filings. That's one thing to do. The other thing to do is write down your job description very, very, very specifically. We want them to know exactly what you're doing so that in an audit, they don't have any back wage claims, because that's the kind of thing. Back wage claims are one of the worst things that can happen in a DOL audit, especially significant back wage claims, because Department of Labor doesn't like to negotiate them. They will, but not a lot. And they're rough. So anyways, be very, very specific about that. Look at your filings, see if there's any way to bifurcate it to make it where you have two groups, one getting paid more than the other, if that's something that your operations can tolerate. And that's basically what you can do for now. And if I'm your attorney, send them to me. I'm more than happy to help you do it too. Okay, so is this implemented on the new regulations that will be published in the Federal Register tomorrow? If so, are you aware of any litigation stop moving forward? First of all, thank you for the awesome question. No, this is not in the final rules that are going to be adopted. Yeah, I guess it's tomorrow. That are going to be adopted, if it's not tomorrow, here in the near future. The ones that were issued last Friday. This is not in those. This is going to be in its own separate rule change. Now, in terms of litigation moving forward, I think that that's something that we need to rally behind. Department of Labor is at a particular advantage here because the folks that this impacts the most have never rallied together. They've never come together to push back on this. And there is a potential way to do that. The way that you do that is once this final rule is published, you seek an injunction. Now, the standard of proof on an injunction is to demonstrate that the rule change is arbitrary and capricious. I think that there are plenty of ways to do that with this rule. I think that there are some significant flaws in the methodology as it was proposed. Of course, I haven't seen the final rule, so maybe they'll straighten them out in the final rule. But I do see a lot of significant issues there. And so what I'm proposing that we do, now knowing the implications that this is going to have on your business, on ag production in the United States, what I'm proposing that we do is that we get together and we hire a law firm, not my law firm, to seek an injunction. And I can coordinate that. I can get with the law firms. I can get with the plaintiff that will be bringing the action. I can find the group that'll help us do that so the Department of Labor doesn't start targeting any one of us. But what I can't do is I can't pay for all of it. And so what I want to see if people would be willing to do is contribute towards seeking an injunction on this. It might not work. We might seek an injunction and it might just cost us money. But I do think it's worth a shot. I think it's worth fighting back against. I think it's worth fighting for agriculture. I think it's worth fighting for agriculture, particularly here in the United States. I think that this thing matters a lot. And I am worried about the implications. Now, look, from my perspective as a lawyer, this doesn't hurt me. This doesn't hurt me, and particularly because I would be doing more filings because people would have to bifurcate their filings. That's not what I care about. I don't want that. I want to actively fight against that. And so anyone that is willing to contribute towards this, I will greatly appreciate it. We're trying to raise $300,000, which is what I've been told by a law firm that I should expect it to cost. And so anyone that is willing to contribute towards that, I would be very grateful. So if you would be willing to contribute towards that, if you'll just please put it in the chat box, as a reminder, only I can see the chat box. So no one's going to know what to do, but I do have someone that just said they would contribute $50,000, and I'm deeply appreciative of that. If this is something that you're willing to contribute towards, we're going to try to raise $300,000. And if you, let's say that we do it, and for whatever reason, it falls through, and let's say we don't spend $300,000, you'll get all your money back, or your percentage of whatever your percentage of what you contributed. So, if you contribute, 10% of it, you get 10% back. So, but anyways, so the implications here are obviously huge. And I appreciate everyone that's continuing to show support and say that they'll contribute. It's something I'm going to contribute to as well. So it's going to be something that costs me money. But anyways, are there other questions? Are there other interest in so can I get a copy of your sheet, of the Excel sheet? Yeah, I'll share the Excel sheet with people. Happy to do that. I probably won't share this exact one. I'm going to refine it a little bit, but I'll share an Excel sheet that's helpful for you. Sure. But I'm going to give people a moment to. Okay, so here's a question. Is this a sure thing to happen? If so, when would it go into effect? I would put my confidence level at about 95% that this is a sure thing to happen. And when would it go into effect? I expect them to issue that final rule change sometime in the next couple months, probably within the next 2 months, I would say is very likely. I appreciate that. Someone just said they're going to match donations, which is awesome. So, yeah, no, I certainly appreciate that. I know it's something worth fighting for. I do love this industry. I love the people I get to work with. I love the farmers and the construction companies. I mean, this is I really enjoy my job. So seeing an attack, particularly on our industry, I do take it pretty personally. So anyways, do we have any other questions? And we will also, here in the chat, if you check the chat, MK sent out ways that you contribute. There's a link right there on how you can do it. And then you can also subscribe right there to our campaign to stay up to date on this. That way, right whenever this thing comes out. What are the odds of being successful and standing up to the DOL? I don't know. Now that this rule has been shot down once, but it was shot down on a different basis. In 2019, right before it was after the election, right before the Biden administration came in, this rule was shot down, and it was shot down on a completely different basis. But it was something that we were expecting to go into effect then, and then it was shot down. And now they've separated the rules, and I think they did that deliberately because they know that people are going to be worked up about the last one, and people are going to be worked up about this one. They took out all the good stuff that was in. So in 2019, that proposed rule change was mostly bad, but there were a few nuggets in there that were really good. So, for example, they were going to, in 2019, they were going to allow post-certification amendments where you could add job sites after certification. They also were going to allow you to stagger entry for up to 120 days. So Department of Labor adopted all the good, but then did not adopt all the bad, adopted all the bad, but did not adopt any of the good that was in the 2019 one. And so I feel very confident that they're going to try to adopt this. And then in terms of likelihood of success, I don't know. All I can tell you is that from my perspective, it is I think it's a winnable action, and really what we need is an injunction. And so it's certainly I do think it's a winnable action. Now, odds, I can't give you odds. I don't know how a judge is going to rule on this thing, and I also don't know what the final rule change is going to look like. So I don't know. You know, at the end of the day, we might all be getting together to push back on the Department of Labor and wasting some money in the process. But I certainly like the idea of fighting back regardless. So. Okay, MK also said that she's going to send over the details for how you contribute in an email. We're also going to be we're recording this just so everyone's aware, and so you are free to share this with people that you think might be impacted by it, people that might be interested in contributing towards it. It's a campaign that I'm passionate about, so feel free to share. All right, well, if you do have any other questions, feel free to reach out. Always happy to help. I'll put my email right here in the chat box. And then, so if you have any, no, I think I just sent that to myself. Sorry, there we go. There you go. That's my email. So if you're trying to get a hold of me, feel free to email me. More than happy to help. But yeah, let me know if you have any other questions. Yes, if you want the spreadsheet, please do send me your email address. Just wondering if we would fall under it for sod farm. I would have to look at your prior filings. If you've had prior filings, it would depend on your SOC code. There's 7 SOC codes that they're going to continue to allow the adverse effective wage rate to apply to. So a lot of times employers will have some jobs that fall under those SOC codes that stick with adverse effective wage rate, and they'll have others that don't. And so we will I would have to look at your prior filings, and then we'd also have to look at your job description to see what the likelihood that you're going to fall under the same SOC code in the future would be. Okay. Oh, here's another question. Good. Equipment operators, tractor drivers, forklift drivers, will they be affected? Yes. So they're, especially if you need a CDL. The truck drivers in particular, I'm pretty sure, I need to look back to see if the equipment operators were, but I think that they were, no, maybe, I think if it was just equipment operators, they were not affected, but if they required a CDL, they were, because they would be classified as truck drivers. But I'm not 100% sure on that. I'll have to look that one up and get back to you. Of course. Happy to help. A Class C driver's license, is that a CDL? Oh, that's CDL. So the best way to, our question utilized the H-2A workers to drive semi trucks using a Class C driver's license. This is classified as a non-commercial driver's license. How would this be coded? There's also another code for not for heavy trucks. Let me see what it was called. Sorry, that's another thing that's going to be happening here is the Department of Labor is going to get a lot stickier about how they classify jobs. So a lot of times historically, they would just group them into, oh, you're doing construction on a farm, you're construction labor. They're not doing that anymore. And it's funny because in the proposed rule change, the way they said it is it's going to impact like 5% of people that file H-2A visas. But the reality is that's not true, because what they're going to do is once this is approved, they're going to go through and they're going to start changing how your jobs are categorized. That's what I would expect, though. And if I'm them, that's what I'm doing too, because one of the things I'm charged with is the responsibility of ensuring that wages and working conditions of U.S. workers are not adversely affected. Fair enough. But I think that what is going to happen, and one of the complications is a lot of people might have gotten old SOC codes, say equipment operators, for example, that might not fall under this issue, but they're going to change it to they're going to change it to where they're gonna be stickier about your particular SOC code because it makes a difference on the actual wages. Historically, it made no difference on the wages, so they didn't care about it. But here, I'm going to show you this real quick. Alrighty. So here's the wage rates. Do you mind putting in the chat real quick what your state is? Okay. So like Iowa, for example, it depends on how they classified you. Industrial tractor operators, 1937, light truck drivers, 1893, heavy truck drivers, 2416. New Mexico, $21.90, 1912, and 2019. So it depends on how they classify your job. And I don't know how the department or how the state workforce agencies are going to do that. That's another thing that drives me nuts about this is I think that it makes it difficult. Oh, was I not ever sharing that? Sorry, let me share there. I think maybe I was already sharing it. Okay. That is one thing that makes it particularly difficult is the state workforce agencies. This is not really fair to state workforce agencies because state workforce agencies are being charged with the responsibility of applying the proper SOC code. But whenever with other filings, with green card filings, with H-2B filings, that you go through an actual process with this, where it's an appealable process. You can request reconsideration with this process with a further explanation through what's called a prevailing wage termination. But there's not going to be a prevailing wage termination for this. It's just going to be strictly on the state workforce agencies to get it right. I don't know how they expected the state workforce agencies to do that. Okay, so on a national, I got this question. MK, will you write this question down for me? Because I'm gonna answer this one afterwards because I'll have to look it up. On the national average, do the iron worker or operators have a higher national average? Equipment operators, that is. Yeah, and I'll look it up for you. All right. All right. So if there's no other questions, I'm going to give everyone a few minutes back, but I certainly appreciate everyone taking the time to talk to us and to hear from us. Oh, there's some questions here in the, sorry, not quite done yet, people. Y'all gonna have to stick with me for one more minute. Let me see if there's any questions I didn't answer here in the Q&A. You have wages for crane operators. I can find them. I'll add that to my spreadsheet. MK, if you'll put that in the notes, that'd be great. Okay. Now I'm actually done. Appreciate it, everyone. If you'll have any other questions, feel free to reach out. Always happy to help. Thank you all.